All right. Hello, everybody. Today I'm going to talk to you about receivership, which is a way for cities and counties to abate nuisance properties. And the agenda, we're just going to go over what a nuisance property is, an overview, a timeline, what it costs, etc. So this is kind of what a receivership property looks like. We've all seen them. They're just falling apart. These are just two recent examples. The roof is falling down. If you drive around, you've seen them. And a recent event is the Ghost Ship fire, which was a tragic thing that happened where the city kept issuing notice after notice. And a receivership might have been a solution that actually saved some lives had they done it. And so receivership really can save lives and help cities actually recover their costs and attorney's fees in the end. So it's really a great solution for cities and counties to use. So this is a very simplistic solution of how receivership works. Of course, nothing in life is this simple, but this is an abandoned, blighted house. You go to the judge. The receiver then essentially acts as a bank, and it was able to borrow with super priority, and then they fix up the house, and it's a nice, productive house. That is the simple view of how receivership works. And it's really only a problem the city can solve. So, like a private person can't bring a receivership action, only an enforcement agency, which is a city or county. And I suppose an HOA could bring one. But really, the city is kind of tasked with the burden of figuring out what to do with these nuisance properties that have been abandoned and left blighted that are terrorizing communities. And so receivership is like the ultimate remedy. There are fines that code enforcement can issue. There's the fines are the main thing, but what happens if the fine doesn't lead to anything? What do you do? And that is what receivership does, and that's what we're going to go into. So a little brief history on receiverships. Really, receivership started back in Old England. And I remember when I was on my honeymoon, I noticed that some of the castles in Europe were put into receivership. And that was because a king would die without a son, and it was left with nobody there, and they had to figure out what to do. And a receiver would come in and manage the castle for a while. And receiverships can really be used in all kinds of things. Essentially, receivership is for when something is out of control, you fix it. So police departments have been put into receiverships. A common example is a corporation is put into a receivership. If a corporation starts going bankrupt, they have all this equipment. Someone has to sell it and make some money, just wind it down, and a receiver does that. Specifically for health and safety receiverships, these are when a property is a huge blight on the community. It's to basically protect life and safety. That's what a health and safety receivership does. And this didn't exist in California until 1988. That's when the legislature enacted Health and Safety Code 17980.6 and 7. It didn't really get used much for the first 10 years. It just sat on the books. But in 1995, the city of San Francisco brought a lawsuit and put a house into receivership. And then in the end, they got their attorney's fees and enforcement costs. Now, it doesn't mean the city just took all their money. Usually there's money left in the pot for the owner. So the city got paid, the house improved, and the owner got a pot of money. But this kind of lit the fire into the cities that, we can actually make money by fixing these nuisance properties. So it started getting used a lot more. Then in 2008, it finally made its way to the California Supreme Court. And this was a big decision that really empowered receivers. It's the city of Santa Monica versus Gonzalez. And in this case, basically receivers are granted huge powers. They can even demolish a property and get super priority. Then in 2012, the Homeowner Bill of Rights was enacted. This encourages owners to get, it allows receivers to recover their fees, and it just really protects receivers. So this also was a way for more receiverships to happen. Now, the real question that usually comes up is, how do these properties end up this way? Why is $1 million property abandoned and left without a roof? And that's a great question. Where does that come from? And one of the most common issues I see is a deceased owner. It's almost like the kings in the castle when they died and there was no one there. So if an owner dies without any kids, what happens to the property? It just sits there. nothing happens. The weeds grow, eventually squatters occupy it. It just becomes a disaster. And the city can issue fines, but what good does a fine do to a deceased owner? It does nothing. So receivership allows the court to come in, take it over, and then you can fix the property. Then there's a zombie foreclosure. And for those of you who don't know what that is, zombie foreclosure was a huge problem in Vallejo back when I was with the city attorney's office. And this occurs when an owner misses a mortgage payment. The bank then issues a notice of default. Then the owner thinks they're being foreclosed on. They assume the bank is going to take it over. And they leave. And then they abandon it, and nothing happens. Then it becomes a blight on the community, just like the deceased owner issue. So it sits there vacant, it becomes a blight. The city issues a citation. The bank says it's the owner's problem. The owner says it's the bank's problem. And it sits there, and it's a blight on the community all over again. But a receiver can come in, take over the property, fix it, and get their fees. Bankruptcy is essentially the same owner, if the same issue. If an owner files bankruptcy, they assume it's done, but it's not, because the automatic stay applies. But there's a police power exception that allows a city to overcome the automatic stay of bankruptcy and take over the property. So those are kind of the issues where it's just an abandoned property. And those are actually fairly simple cases. But then you have your hoarder issues, which are a lot more difficult. We all know what a hoarder is. And we actually had a recent case where there was a hoarder, he had like 30 propane tanks next to his electrical, which is not good. That's not a good combination. But to deal with these properties is a lot more difficult because it's a mental health. They're not just gone. You have to like work with them, and you can't just come in with like a hammer usually. You have to work with them, and these are difficult cases, but I actually like these cases a lot because they usually come to a good resolution. Then there's like drug houses. The other two are self-explanatory. But then there's also drug houses. We just had one in Elk Grove where there was 200 calls for police service in less than a year. And there was like a gunfight every week. And that was obviously a problem. So in that situation, we came in, we got all the tenants out. It was a slumlord leasing to all these people. We reached a settlement with the tenants. They left. We were able to fix everything up, sell it, and it was a great result. So these are just some of the various stories that come up of how these properties end up, without the roof and all these various problems. These are kind of the explanations. So when you go to appoint a receiver, when you're in front of a judge, these are the three elements you need to prove. Number one, the property substantially endangers public health and safety. Prove there is a reasonable time to abate the nuisance, and that the receiver is qualified. So a judge will evaluate all three of these things, and they'll say, yeah, the property is a danger. Yeah, they've had a reasonable time to abate the nuisance, and yes, this receiver is qualified. So everything goes through the court, which is, I think, a really good thing. All right. Now, these are the documents used to appoint a receiver. See, it's kind of an exhaustive list, and it should be. You have to issue a citation, a warrant, blah, blah. And I'm going to get into all these a little more throughout the presentation. But essentially, you're taking someone's property away. And there should be a lot of notice before you do that. It shouldn't just be, hey, you didn't cut the grass, you're in a receivership tomorrow. It's a huge, huge remedy. And these are the various documents necessary. And as I said, we'll get more into that. So this was a case I did in Vallejo. This was actually one of my first receivership cases when I didn't know what to do. The owner was deceased. There was a bank, Wells Fargo was involved, but they were not, I couldn't contact them. They just ignored it. And, the problem sat, and code enforcement issued citation after citation. And clearly, if she's deceased, we have zombie apocalypse on our hands if she responds, but that didn't happen. And I heard about receivership at a seminar like this, and I was like, oh, maybe that'll work. And so we went in front of Judge Mattias, who actually ended up hearing 50 of these cases. We said, And this is the 97-page document. This, as I said, all those documents we saw on the previous slide. These are all the, this is the first petition. You have all the notices, the citations, all the various documents that show how and why this property needs to be in receivership. We got in there on September 11th, 2013 is when the petition was filed. And then it took about 1.5 years, but it was fully rehabbed, remodeled, and eventually sold to a nice family. And I actually drove by it on the way here, and it looked really nice. So it went from being a disaster to a productive use. And the city ended up making $10,000, and it was a great success. And then once I did one, I got hooked, and I think I ended up doing 20, I'm gonna say 25. And specifically in Solano County, Judge Mattias hears every single one of these petitions. I know he just retired, and now Bradley Nelson hears them. But Vallejo has done so many of these cases since we started. I think we've done a total of 50, that it's a really effective remedy in Solano County. So.
What happens with the mortgage?
So oh yeah, it's a great question. So at the end, so in this one, we sold it. And the banks always come up once the money's on the table. So we sold the property for, I'm gonna say $200,000. And the bank said, oh, we want our slice of the pie, which is not unexpected. And then we said, well, we want our attorney's fees. They said, we'll write you a check for $10,000 and give us the remainder. The receiver made his fees of, I believe it was like $35,000. The city got $10,000. The bank got their mortgage paid off. And then there was $30,000 left, but she had no kids, so we interpled the funds, and I guess it's still with the court to this day, because a lot of times there's money left over, and some people, just as an aside, we just had a case in Santa Rosa where we sold the property and we had $500,000 left over, but the owner thinks the government's after him and won't open a bank account. So we were like, here's the money, take it. And he said, no, I don't want it. So we put the funds with the court, and it's still there. But so usually there's money left over. Of course, there's exceptions, but yeah, usually it works out. Yeah.
How do people go buying these properties? How do people find out about
That's a great question. So usually we hire a real estate broker, but a lot of times what we do, technically under the statute, you're supposed to do an auction, and you go to the city clerk. It's like it's not the same as a trustee sale, but it's essentially an auction procedure. So you put it in the paper, you put it in the city posting, and for I believe 4 consecutive weeks. And yeah, we usually have quite a crowd at the auctions, and then they sell it. You can sell it independently, because sometimes, for like that one with the 200 calls for police service, we obviously didn't want that owner owned like 30 properties, so easily could have bought that property back, and that would have not been productive. So we sold it to we had a real estate broker just list that one, because we didn't want him or any of his family buying it, because he just got convicted for fraud like 2 days ago. He was a crazy guy. But yeah, most of the time it's an auction process, but you can just, list it, and it goes in escrow like that property. But that's a very good question. Thank you. And this is just kind of like the hidden cost of what these properties do. So for this particular one, we had 11 different inspections of the property. The police department had been called to it 12 times. And the building department was there 11 times. And code enforcement was there 33. And obviously the residents didn't like this place without running water and squatters being there. So, I don't know the exact costs of all of those visits to the property, but obviously it adds up. And finally, when we abated the nuisance, the property was fixed and this wasn't happening anymore. So, all right. So this is just kind of a list of how you actually get a receiver appointed, like the nitty-gritty of it. So as we discussed, the 3 elements are substantially endangers public health and safety, had a reasonable time, and a receiver is qualified. Now for these 3 things, there's no black and white answer. Obviously, the more pictures you have of the property being a danger, the more notices, the more citations. If there's been a big fire on the property, that's pretty self-explanatory. If the grass hasn't been cut, that's probably not enough. Reasonable time is the same thing, 1 day, not enough. A year or two, probably plenty. But you have to give notices throughout the process. So I'll kind of get into what those notices are and why they're so important in this process. So this is just kind of a list of the various receivership laws that are applicable. The one that we always use in these cases is Health and Safety Code 17920.3. It's like a laundry list of violations. It's like 4 pages in the statute book. And it goes from like faulty wiring to rough partitions, no electrical. It just, anything you can think of in a property, it's in there. And these are the specific statutory receivership statutes below, and we'll get into that. And then just to go back to your question about selling, Civil Code of Civil Procedure 568.5 is specifically what empowers a receiver to sell the property. And that has like a specific auction process to be used in it as well. All right. So how you build a receivership case. So, you see a property like we saw at the beginning of the presentation that doesn't have a roof. What do? You call code enforcement, and they go out and say, yeah, this is obviously a problem. So they will usually just issue a courtesy notice and say, hey, fix your property. And 9 out of 10 times that works, like people will say, if someone gets a letter from the city, they'll fix it. These receivership cases are for those 5 to 10% of properties where that won't work. But you still send that courtesy notice because that is how it gets started. Now, assuming you send that courtesy notice, then you send a notice of violation, probably have a fine included. And that a fine gets even more people's attention. But if that doesn't work, well, then the next step might be looking to a receivership. But before that, you might want to get an inspection warrant and really go in, because if it's bad on the outside, it's probably even worse on the inside. So when you go into the property, which you can with an inspection warrant, you see how bad it is, you take the pictures, and that'll all be evidence to be used. And you can send a notice to the owner with those pictures saying, this is really bad. And you take pictures throughout the whole process. So those are kind of like the building blocks of the receivership case. They're not required, but they're definitely recommended reading. Yeah.
So question, does your group, who reports to code enforcement? If you notice, I'm sure neighbors do.
Oh, yeah.
Do you drive around and you say, oh my gosh, and there's a property that's falling apart, and then you call code enforcement and say, hey, this needs to be fixed, or something along those lines? Who does the reporting?
I usually don't. So what happens, how we usually get cases is like a city will come to us with a problem, like, what do we do? Like, we've been trying to figure this out, or they've heard of receivership, and then I've like reached out to various people. But yeah, basically these cases have been going on for a long time, and they don't know what to do, and they reach out to us as an example. And then I usually walk the city attorney through this process because they haven't done it, and yeah, so that's what happens. So yeah, the abatement warrant. And then the next thing you're going to want to do, so as I mentioned, those are kind of like the first 3 steps. You don't have to do them, but you should. The first official step in starting a receivership is the Health and Safety Code 17980.6 notice. And something you want to do before you issue this notice is get a title report on the property to identify all the recorded interests, which will show, the bank, the owner, any judgment liens. Sometimes these title reports can have 20, 25 people on them. Sometimes it's just one, but more or less, they're usually pretty complex titles. So the California Health and Safety Code, I'm just gonna call it a 0.6 notice moving forward. This is kind of your roadmap in the case. And this has to list all the violations on the property. The more violations you list, the better, because this is what the receiver uses moving forward. If you have one of those buildings we saw without a roof and you say, the grass isn't cut, if the receiver cuts the grass, the owner could come in and say, the grass is cut, the case is over. But if you put, roof missing, faulty wiring, so on and so forth, the receiver is allowed to abate all those specific violations. So you want to be very over-inclusive in your 0.6 notice, because that could come back to haunt you if you don't do it properly. You also want to have a reasonable time listed in there. So the notice is usually, the 0.6 notice is usually like 4 or 5 pages of violations, and then it will tell the owner, between 15 and 30 days. There's no, as I kind of mentioned earlier, there's no set time for reasonable, but usually you've sent that courtesy notice, the citation, and done the inspection warrant. So it's not like it just popped up. But this 0.6 notice, I usually would put 15 days, but there's no right or wrong answer. Yeah.
Question, so what happens when the owner is deceased and there's no probate opened up for this individual? What do you do about properties like that?
Yeah, that's a great question. We just had one in Vallejo. Yeah, that just happened. So what we did was, the owner was deceased, and then, Judge Mattias appointed us as receiver because it was falling apart. He said, something needs to happen. And then eventually we tracked one of the heirs down, and we were like, hey, you have some money on the line. And then she hired a lawyer. It was like a second cousin or something. But, through intestacy, we figured out she was the heir, and she opened the probate, and then we sold the property, and then there was about like $75,000 left, and closing escrow was actually a problem with that, because they were getting title insurance was a little bit of a problem. They were kind of like, well, there's no probate open, what do we do? And so we got a probate open, and then we got an agreement where we said if we interplead the funds. If you don't remember from law school, interpleading is depositing money into a court. I had forgotten that until it came up. But so we deposited that, and once we had an agreement with the title company, they're like, oh, great, we'll close it. But having the probate things are an issue, with especially closing the sale.
Do you have to have the probate open first before you move forward,
No.
Or you can move forward?
You can move forward. We just take the risk as the receiver of not getting paid or not being able to sell the property in the end. But the judge, through the police power of the state, is like, this thing is on fire. Someone should put this out. Yeah. So, it's just a huge risk as the receiver to do that. But we do it. Yeah. And it's never not worked out. But that's a great question. Thank you. So back to the 0.6 notice, what is a reasonable time? As I mentioned, 15 to 30 days. And then usually the owner doesn't respond, as they haven't responded throughout the whole process. They just kind of ignore it. So what happens when the reasonable time expires? Great question. You then have to get a 3-day notice under California Health and Safety Code 17980.7. And this is kind of weird because you get a notice of hearing before a lawsuit is filed. You have to serve a 3-day notice before filing the petition. So a lot of times when I would serve banks or something, they would say, what is this? There's no case number. There's no hearing date. What are you doing? And I'd say, well, it's how it's supposed to be. And they'd pretty much ignore this. And actually, they just amended the law. Gavin Newsom just signed an amendment into law on October 8th saying you can just mail it to everybody. You had to personally serve everybody before, but now you can just mail it. And it was a huge issue because you would serve these people that were, sometimes they were dodging service. You'd finally track them down. They'd get served, and then they would run away some more. So anyways, they changed the law, and that was great. So then you serve the 3-day notice on all parties with their recorded interest, so they have notice. Once that 3 days expires, then you can actually file the lawsuit. Very exciting. Once the reasonable time happens, you've done all your packaging. So as I brought up that 97-page document, it's going to have the courtesy notices, it's going to have the fines, it's going to have the inspection warrant. All that's going to be to show that the property is a substantial danger to public health and safety. Then you're going to have your 0.6 and 0.7 notice to show the owners had a reasonable time to fix the property. Then finally, the receiver submits a declaration explaining their experience. And so the judge considers those 3 elements. Hey, this property is a substantial danger, the owners had a reasonable time, and the receiver is qualified. And then the exciting day comes, you have your receivership hearing. And this is usually pretty exciting because you never know who's going to show up to these things. You haven't heard from anybody for a year or two, but all of a sudden there's a lawsuit, there's money on the line, and the banks show up, the owner who hasn't said anything shows up, and they always ask for more time. They say, oh, we need more time. But that's why it's so important to document everything, because you say, why do you need more time? I gave you a notice on December, January, February, March, April. You haven't responded to me one single time. Why would I trust that you have more, that more time will do this? And it's really important too, because I've had cases where they've granted more time and then the property burns down before we get there. Because these are like really bad situations. I mean, it's only happened 2 or 3 times, but yeah, they like one time the judge said, oh, give them 60 more days. And then 10 days later, the property burned down. And that's why you document. That's the importance of document. So anyways, and then just as an aside, there's actually a recent appellate case decision where it said a noticed motion is how you decide this. You don't have to have live testimony to appoint a receiver. So that just got decided, and I've been citing it. So, yeah.
When property burns down, then that's one of those losses that you wind up taking.
Well, we still ended up, because we didn't even get appointed yet. We still ended up getting appointed, and like, yeah, we just fixed the property because we don't get paid by the, we bill by the hour. So like, you know, it was like a nice house. It actually happened in Vallejo again. Yeah, it was like, we got appointed after it burned down. We went in ex parte after it burned down saying, hey, we should fix this. And they appointed us as receiver. And then we were able to rehab it, and then we sold it. And yeah, we got fully paid on that particular one.
Do you ever have a house fully gutted? Because that sounds like it's in pretty bad condition.
Yeah.
And then you just replace it with a complete brand new house?
I don't think you can rebuild a house. I've never like rebuilt. We've demolished and sold the land. So yeah, that's actually a great point. So there's 3 things essentially you can do as the receiver. You can be appointed and fully rehab the property, then sell it. You can demolish the property and sell the land, or you can just take the property and sell it to a responsible owner kind of as is. I mean, you still kind of clean up the Band-Aids. And for like lower value properties, we have to do that. Like we have a few cases in Fresno where the value is so low, all we can really do is come in and sell the property as is. Like we board it up, we clean out the debris and all that, but the expenses would outweigh the value of the property. But in the Bay Area, that's never a problem. There's always plenty of equity in the properties.
How large is your territory if you extend all the way to Fresno?
We've gone all the way down to San Diego. We probably need to change our name from Bay Area Receivership Group, which is something we're currently discussing. But we try. I mean, we like to be in the Bay Area because it's easier. But I mean, it's a California law, so it can happen anywhere. But yeah, that's the first thing. Because San Diego called us. They had a couple properties, and they were like, you guys go outside of the Bay Area? And we said, sure. I'm like, oh, you should change your name. And we haven't. So then that exciting receivership happens. You had all your documentation. The bank said they need more time, but the judge says, no, let's fix this today. Then at that point, the receiver is appointed. And then immediately after that, you file an oath, a bond, and an inventory with the court. And then you obtain funding, and a receiver can get a super priority loan over all other liens. So if there's like a Wells Fargo or if there's a bunch of mortgages, we get paid first for our services because we're fixing the property and they're sitting in the background. And so that we go to court, we get funding, the court approves our funding, and we use that money to rehab the property. And then throughout the process, we have to file a monthly report kind of explaining what we're doing. And throughout the entire time, any party can object to our report and say, hey, this is wrong. And because it's an equitable remedy. We're actually, a receiver isn't an agent of any party. We're an agent of the court, a neutral, so we have to report to everybody. And someone can say, and they do, sometimes the owner will say, hey, we feel like we're getting screwed, and we have to respond to that. But usually, I mean, honestly, 9 out of 10 times, these things work out very well. We sell the property, the owner gets paid. There's plenty of money to go around, and these properties are in a terrible position. So if we come and fix them, sell them and give the owner money, that who's going to complain? The only problem is, it's a lot of work, so cities, have to go through all this process of notifying and notifying and notifying, and that's something I really help cities with, is like explaining this process. And I've done like 60 of these petitions myself, so it's something I know very well. And then, so once that's all done, you file your monthly reports, you sell the property, then the city gets to make their attorney fee motion, and their statutory authority to do that is .7, C11, and D1. So they can recover their attorney's fees as well as their enforcement costs. So that means like police time, firefighter time, any of that time can be recovered. And some cities get some very big awards. Like we've had a few cities get $150,000 for their time. Usually it's a lot less than that, but that's available. So then once the city submits their receivers, their attorney's fees and costs motion, then we file what's called a discharge of receiver, which allows us to basically walk away. If a city wants, they can keep the case open for 18 months, but that's very rare. Usually the property is sold, everyone's happy, unless you're the one guy who doesn't collect his $500,000. But yeah, and it's just really a good case. And in actuality, the city and the county does not pay anything for these services. The receiver can't accept money for anybody, so it's absolutely free for a city or a county to do it. So it's really a great remedy, and that's why Vallejo does it so much. So yeah, that is the presentation.
Which county do you find this happening
Well,
most?
definitely Solano, because Solano County does it so much, but Alameda County, we have a lot of cases with we have one in quite a few in Oakland, Emeryville, Hayward. There's so many like little cities in Alameda County. We have a few in San Francisco. Fresno, we're getting a lot in Fresno actually. Yeah, they're kind of all over. But there's a few, it's kind of like a new thing. Even when I did it with Vallejo, I was kind of like, what is this? It sounded like too good to be true. And I was like, what's the catch? And the catch is it's a lot of work. That's the catch to it. But it does work out really well if you do it, but it does take time.
Are you the only folks anywhere around here that do this?
We're the only ones in the Bay Area. There's a few people in LA that do it, but yeah, that's kind of why we went with Bay Area Receivership Group, because we wanted to distinguish ourselves. But there's 2 in LA that are very prominent, yeah.
You call yourself the California.
I know. Well, he took his name. He's California Receivership Group, so he has it.
The galaxy?
Yeah.
I need a royalty on that. So, do you think this could be used in conjunction with the Red Light Abatement Act?
Oh, definitely, yeah, it can. Yes. Yeah, you can do the Red Light Abatement Act or the Drug Abatement Act. Either one can be used to appoint a receiver, and the city also gets a $25,000 fine. That's what we did with the Elk Grove one, where I mentioned, where the 200 calls for service and all that, and they got their $25,000 fine, and we sold the property. Yeah, that's a great question, but yes, definitely.
So you'd go with the Red Light Abatement proceeding first?
Yeah, you get a judgment, and then you can appoint a receiver to do it. Yeah. Yep.
In general, can you generalize how long it takes from receiving the property to rehabbing to sale? How long does that process generally? Does it take a year? Does it take 2 years?
So usually, like once we're actually appointed, like once all this stuff gets done, it's usually like between 4 to 8 months, I would say. Like we just got this huge property in Hayward. It's like an old abandoned college and medical building. Like it's a $20 million project, and that's going to take a while. But usually the single family homes, I would say between 4 and 8 months from being a disaster to being on the market and sold and looking pretty.
So you handle residential property and commercial?
And commercial, yeah. There was some debate about whether it could be appointed, whether commercial properties could be put, but we've had a few cases now where it's happened, because the statute says residence, but we've had it happen on commercial properties and no one's objected to it, so it can be done.
If the nuisances
Yeah.
are abated, let's say you've put in, 15, 20 hours, attorney's fees. If they're abated, that's kind of you're not going to get paid.
Yeah, you kind of lose that unless the receiver is appointed. Yeah, if you go through that process. I mean, usually it doesn't because usually these people are, like I said in the deceased owner one, no one's going to show up. But yeah, if it's like a slumlord one, yeah. So yeah, you kind of sometimes you eat your cost or it gets fixed or something happens. Yeah. Yeah. All right. Oh yeah. Yes.
I was just thinking of a situation where a city maybe is unfamiliar, just has some complexities,
Yeah.
good at it,
Yeah.
but they can just call it Bay Area then, and really you will come in at no cost obligation as far as just getting the process going and see if that's something the city wants to do
Yeah.
or not.
Yeah. We do that all the time with cities where we just say we'll help you because essentially that's what they're always a little confused because I'm like, yeah, you can call me and I won't bill you because if you do it right, we'll both win in the end. So call me, I'll walk you through the process. Because if they don't do it right, like if they don't do that 0.6 notice correctly and then the case falls apart, we both kind of lose. But if I just walk them through it, we're both going to get paid in the end. Yeah. All right. All right.
I have another.
Oh, sure. Yeah. No problem.
So the first thing is identifying a property where there's a substantial risk to health and safety.
Yeah.
I guess if there's like squatters in there or drug users in there, that makes it a little bit easier
Yeah.
to show that. But if it's just abandoned, there's no one there, how are you going to show that there's a risk to health?
So that's where, because usually it gets occupied, and then a lot of times that's when you get the inspection warrant to go inside, and then you find all kinds of problems. And I think just abandoned properties don't just stay. Usually someone ends up breaking in, but technically if it just sat vacant and nobody was doing anything, and then someone was coming around cutting the grass, nothing would happen. But yeah, they fall apart pretty quickly, it seems. Yeah.
Can you argue like attractive nuisance, like kids could go there?
You could, yeah. And I've seen some cities be like, yeah, it's vacant and unsecured. Within the municipal code, that can be a violation in of itself, and that could be enough. So, yeah, because it's almost like why wait till this becomes a problem? It's vacant and unsecured. It's only a matter of time. So, and some cities are really aggressive. I know, like, this is done a lot more in Southern California. Like, kind of when I started doing it in Vallejo, there weren't that many places in the Bay Area doing it, and it's definitely picking up. But yeah, in LA, like in Orange County, they're very aggressive and they do a lot of receiverships. And I think even if it's vacant and unsecured, yeah, their position is like, this is an attractive nuisance. It's going to be occupied by squatters. Why wait until a fire starts? Let's deal with it today. Yeah.
Are there cases your group refuses to take? Is there any case too bad?
Yeah, definitely. Well, and it really has to do more with the property value, to be honest. Like, it's kind of like Weed, California, like asked us to do it. I don't know if you know, it's super in Northern California, and the property values are worth like $20,000, and for us to commute all the way up there, it was just kind of like it's not worth it. So it really has to do more with the property value. And then there's some where it's like, wow, this person is really litigious, Like we've had a few. I mean, we did one where someone was a vexatious litigant, and they just constantly sue, and it's a lot of work to fight them. So maybe we shouldn't have taken that one, but we did. So it's a lot of work. But most time, particularly in the Bay Area, because the properties have so much value, we almost always take them. But we do an evaluation. And then another issue that actually comes up in the title report, if there's like a huge tax lien, because we don't get super priority over tax liens automatically. So if we see like a $2 million tax lien, we're kind of like, well, that's going to be a fight. So we'll talk to the IRS before, kind of saying, will you subordinate? Sometimes they agree, sometimes they don't. If they don't agree, then we don't move forward. So that's happened a few times, but 9 out of 10 times, if the property is in this state, we usually take it, yeah. Yeah. All right. Thank you very much.